Welcome to the deep dive. If you've ever, say, signed a gym membership or bought a house, you've dealt with the most fundamental thing in commerce, the contract.
That's right.
Today, we're really digging into that absolute moment of creation. Our mission is to basically build a blueprint, point by point, for figuring out if a promise is legally binding and what actually kills the chance to accept it.
Yeah, we're starting right at ground zero. The whole validity of any agreement, it really rests on three pillars. Mutual assent, that's your offer and acceptance, then consideration, and finally, making sure there aren't any valid defenses.
Okay.
But you can't even tackle those until you do the threshold check first. Which set of rules applies? Common law or UCC?
Yeah.
Only then can we break down the offer itself, that legal step that gives the other party the power to, well, seal the deal.
Okay, let's unpack that right away,
Okay.
because that first step seems critical in any analysis. Which rulebook are we playing by?
Yeah.
How does the law divide things up for different kinds of deals?
Well, the big split is between common law and the Uniform Commercial Code, specifically Article 2. Think of common law as handling the stable stuff. Services, jobs, land, even intellectual property.
Hmm.
The UCC, Article 2, that's for contracts involving the sale of goods.
And what exactly counts as a good? How specific does that get?
Think tangible and movable. Basically, goods are anything physical you can pick up and move when the contract is made. Cars, computers, grain, that kind of thing.
Right. But what about those trickier situations, the hybrid contracts? Like you hire someone to build and install custom kitchen cabinets. You've got the goods, the cabinets, but also the service, the installation. Which rule book then?
Yeah, for those you need the predominant factor test. The court basically weighs it. It looks at the whole contract and asks, what's the main point here? Is it mostly about buying the cabinets, or is it really about the installation service?
Right.
Whichever purpose is dominant, that law governs the entire contract. So if the service part, the labor, is just sort of secondary to getting the goods, then the UCC applies to the whole thing.
Perfect sense. So once we know the governing law, we start looking for the offer. We know an offer creates this power of acceptance, but how does a court figure out if the person making the offer really meant to be bound? What if they were just joking?
Courts don't read minds. That's the core idea behind the objective theory of contracts. Your intent isn't about what you secretly felt or thought. It's about your outward actions, your words. What would a reasonable person standing there conclude you meant?
So even if you were kidding inside.
Exactly. If you seriously offered your rare baseball card for $500 as a joke, but it looked like a real offer to a reasonable person, a court might just hold you to it. Your hidden subjective intent, pretty much irrelevant.
Okay, so for an offer to actually create that legal power, it needs, let's see, 1, that objective intent to be bound.
Yep.
2, sufficient definiteness like price, quantity, who's involved.
Crucial.
And 3, it has to be communicated to a specific identifiable offeree. If you've got that trio, boom, the offeree suddenly has the power to form a contract just by saying yes.
You've nailed it. It's like you've deputized them, handed them the trigger to instantly create a binding deal.
But that power isn't permanent, right? It's fragile. The offerer can usually take it back, revoke it any time before it's accepted. But what if they don't send a formal I revoke letter? What about indirect signals? How does that work?
Right. Direct revocation is pretty straightforward. It's effective when the offeree receives it. But for an indirect communication of revocation under common law, it's stricter. 2 things absolutely have to happen.
Okay, what are they?
First, the offerer has to take some definite action that's clearly inconsistent with the offer still being open, like, selling the thing to someone else.
Makes sense.
And second, the offeree has to find out about this inconsistent action and, crucially, learn it from a reliable source. If both those elements are met, the power of acceptance just vanishes. Poof.
Okay, this sounds like a perfect setup for a classic case, Dickinson v. Dodds. Let's walk through that. Dodds offers to sell property to Dickinson, saying the offer's open until Friday. But on Thursday, Dickinson hears from someone else, a third party, that Dodds already sold the property to another person. Dickinson then rushes to accept the original offer.
A classic indeed.
Let's analyze Dickinson v. Dodds. First, what are the legally dispositive facts?
The key facts are the offerer, Dodds, sold the property to someone else before the deadline, and the original offeree, Dickinson, found out about that sale from a reliable source before he tried to accept.
And what was the core legal issue?
The big question was, does learning indirectly, kind of through the grapevine, that the offerer sold the property count as an effective revocation, even without direct notice from the offerer?
What rule did the court apply?
They applied that rule of indirect communication of revocation we just discussed, requiring both the inconsistent action by the offerer and the offeree learning about it reliably.
What was the court's analysis? How did they connect the dots?
Well, the court reasoned that Dickinson knew Dodds wasn't planning to sell to him anymore because he'd already sold it elsewhere. Learning this, even from a third party, meant Dickinson effectively had noticed that Dodds was no longer committed to the original offer. That knowledge terminated his power to accept.
And the conclusion?
The conclusion was that Dickinson's attempt to accept was too late. It was invalid because the offer had already been effectively revoked indirectly. No contract.
So that covers termination by revocation. Another major way offers die is through the offeree's response. If the acceptance isn't a perfect match, it actually kills the original offer and becomes a rejection specifically, a counteroffer.
Oh.
This brings us to that really strict common law idea, the mirror image rule.
Oh yeah, the mirror image rule is unforgiving is a good word for it. Under common law, if your supposed acceptance changes anything, adds a term, removes a term, tweaks a term, it's not an acceptance at all.
What is it then?
It acts as two things simultaneously. First, a rejection of the original offer, killing it dead. And second, it's a brand new offer, a counteroffer, back to the original offer.
Let's test that strictness with Ardente v. Haran. Here, the buyer sent a letter accepting an offer to buy real estate, but they added a bit asking about certain furniture being included in the sale. Let's analyze Ardente v. Haran. First, what are the legally dispositive facts?
The buyer sent back what looked like an acceptance for the house, but included a specific request, essentially asking for confirmation that certain items of furniture, like the dining room set, would be part of the deal.
And what was the core legal issue?
The court had to decide. Was that letter just a simple inquiry about the furniture, which wouldn't kill the offer? Or was it making the acceptance conditional on getting the furniture, turning it into a counteroffer under that strict mirror image rule?
What rule did the court apply?
They applied the mirror image rule, which, as we said, demands that an acceptance has to be absolute, unconditional, and match the offer exactly.
What was the court's analysis?
The court looked closely at the language. They decided it wasn't just asking, hey, is the furniture included? It read more like, I accept, provided that the furniture is included. Because it added that condition, it wasn't a mirror image of the original offer, it changed the terms.
And the conclusion?
Therefore, no contract was formed. The buyer's response was deemed a rejection of the original offer and a counteroffer, which the seller never accepted.
So the parties themselves can kill offers through revocation or counteroffers. But sometimes the law itself steps in and terminates the power of acceptance automatically. This is termination by operation of law. Offers obviously expire after a set time or a reasonable time. But what about the really drastic one? The offerer's death or incapacity?
Yeah, this one's quite absolute under common law. If the offer dies or becomes legally incapacitated, like declared mentally incompetent, before the offer is accepted, the power of acceptance is just extinguished.
Even if the offeree doesn't know.
Even if the offeree has no idea. The rationale, the policy behind it is that you can't have mutual assent, a meeting of the minds, if one of the minds legally no longer exists or lacks capacity. It's harsh, and there's some criticism, but that's the traditional rule.
That rule sets up one of the most memorable hypotheticals in contract law,
Yeah.
kind of drawn from the Pedersen v. Patberg situation.
Yeah.
Picture this. You've got a deal where you can pay off your mortgage early for a discount, a unilateral offer. You drive across town, find the guy, you're literally pulling the cash out of your pocket, ready to hand it over, and just as the money is about to change hands, he yells, "I revoke."
Ouch. Yeah.
That feels incredibly unfair. Under the really old common law, like in Pedersen, could he actually do that? Was that revocation effective?
Under that very rigid old interpretation, yes, possibly. Because the final act requested by the offer, the actual handing over of the money, hadn't quite happened yet, the offerer was still considered the master of the offer right up until the last microsecond of performance.
So how does the modern rule prevent that kind of, injustice?
Thankfully, the modern approach, found in the Restatement Section 45, is much more reasonable. It says that once an offeree starts performing, or tenders performance, like holding out the cash, in response to a unilateral offer, that creates a temporary option contract.
An option contract.
Yeah, essentially, it makes the offer temporarily irrevocable. It legally binds the offerer to keep the offer open for a reasonable time to give the offeree a fair chance to finish the performance they've already started. So under the modern rule, yelling, "I revoke," at that moment, likely ineffective. The offeree is protected.
That protection makes sense. And it leads us nicely into the exception situations where offers become irrevocable. You just mentioned one. What are the main ways an offer can be locked down, preventing revocation?
There are basically 4 key mechanisms you need to look for. First, a standard common law option contract that's a separate promise to keep the main offer open, and it needs its own consideration, like paying a small fee for the option.
Okay, number one.
Second, beginning performance in a unilateral contract. Under Restatement Section 45, like we just discussed with Pedersen, starting the job makes the offer temporarily irrevocable.
Right.
Third, detrimental reliance, often called promissory estoppel. This is big in construction bids, like in the Drennan case. If a subcontractor makes a bid and the general contractor relies on it to make their own main bid, that reliance can make the subcontractor's bid temporarily irrevocable.
Okay, reliance. And the fourth.
And finally, number 4 is specific to the UCC, the merchant's firm offer under Section 2205.
Ah, the UCC again. That firm offer rule is interesting because it seems to ditch the need for consideration, which is usually fundamental. What are the specific requirements for a UCC firm offer?
It's got 3 essential elements. 1, it has to be an offer by a merchant. 2, the offer must be to buy or sell goods. And 3, it must be in a signed writing that explicitly gives assurance the offer will stay open.
And the big difference from a common law option.
The biggie is no consideration is needed to make it irrevocable. However, there's a time limit imposed by the UCC itself. Even if the writing says the offer is open for 6 months or a year, the UCC caps the irrevocability period at 3 months.
This move towards more practical, flexible rules really ramps up when we get to UCC acceptance, doesn't it?
Oh, right.
Why did the UCC feel the need to basically tear down the common law mirror image rule and create the whole complex battle of the forms under Section 2207?
Well, the main driver was practicality in modern business. Think about how companies actually operate. They send pre-printed purchase orders, then the seller sends back pre-printed invoices or confirmations. These forms almost never match perfectly.
Right, the oil plate terms always clash.
Exactly. Under the old mirror image rule, that meant technically no contract was ever formed by the paperwork. And worse, it led to the last shot rule, where whoever sent the last form before the goods were shipped got all their terms included if performance occurred. The UCC drafters wanted to recognize that, look, when businesses exchange forms and then ship or accept goods, they intend to have a contract, even if their forms don't perfectly align.
So how does UCC Section 2207 actually change the game? What's the core mechanism?
The revolution starts in subsection 1. It says a definite and timely expression of acceptance does operate as an acceptance forming a contract, even if it states terms additional to or different from those offered.
Wow, so the different terms don't automatically kill the deal.
Not automatically. The only way, really, to prevent contract formation at that stage under 22071 is if the acceptance is explicitly made expressly conditional on the original offeror agreeing to those new or different terms. That's a high bar.
Let's apply this. What about something consumers face all the time, those terms in the box you find when you open software or electronics? Does 2207 mean consumers are just stuck with whatever terms the company put inside, like in the Klocek v. Gateway case?
Klocek really shines a light on how crucial it is to figure out who made the offer first. There's actually a split in how courts handle this. In Klocek, the court took the view that the consumer makes the offer when they place the order or pay.
Okay.
So when Gateway shipped the computer, that was the acceptance, the terms inside the box. Those were seen as proposals for additional terms to the already formed contract.
And since the consumer isn't a merchant?
Exactly. Under 22072, additional terms only become part of the contract between merchants automatically under certain conditions. For a consumer, those terms in the box are just proposals that require the consumer's explicit agreement, their express assent. Simply keeping the computer wasn't enough in Klocek's view, which differs from some other cases like ProCD or Hill. It really matters who's the offerer.
Okay, this is complex but fascinating. We've gone from the rigidity of common law to the, well, sometimes confusing flexibility of the UCC. For someone listening, maybe facing an exam or just trying to analyze a potential contract issue, can we synthesize this? What's a step-by-step diagnostic checklist they should run through for offer termination issues?
Absolutely. This is your issue spotting framework for termination. Run through these questions systematically.
Was a valid offer even created? Check those basics. Intent, definiteness, communication, no offer, nothing to terminate.
Right. Step 1.
Second, did the offer try to revoke before acceptance? If yes, was that revocation effectively communicated? either directly upon receipt or indirectly meeting the Dickinson test, inconsistent act plus reliable notice.
Okay, revocation check.
Third, did the offeree's response kill the offer? Was it a rejection or a counteroffer? If it's common law, apply that strict mirror image rule. Any change makes it a counteroffer. Remember ardente. If it's UCC, you've got to go down the 2207 path we just discussed.
Mirror image versus UCC 2207. Got it.
Fourth, did the offer simply expire? Did it lapse because the specified time ran out or just a reasonable amount of time passed?
Time lapse.
Fifth,
Yeah.
did the offeror die or become legally incapacitated before acceptance? Remember, under common law, that's usually an automatic termination.
The harsh one. Okay.
And finally, sixth, if any of those termination events happened, revocation, rejection, lapse, death, was the offer nevertheless irrevocable? This is where you check for those exceptions. Was there a common law option contract supported by consideration? Had the offeree begun performance in a unilateral contract? Was there detrimental reliance, promissory estoppel? Or, under the UCC, was it a merchant's firm offer?
That's a fantastic checklist. That structured approach really seems like the key to cutting through the complexity here. We've seen the stark contrast, the common law where just asking about furniture can sink the deal versus the UCC trying to salvage deals even when the paperwork clashes.
It really highlights that core tension, doesn't it? Between wanting predictable, strict rules and needing flexible rules that match how business actually works. And while UCC 2207 adds flexibility, it does leave that one escape hatch we mentioned.
Right, that phrase in 2207, making the acceptance expressly conditional on assent to the new terms. If you fail to use language strong enough for that,
Then you might have a contract under 22071 on terms you didn't fully agree to. Or, if the forms are just too contradictory, you might still have a contract based on conduct alone under 22073, where the court throws out the conflicting terms and fills gaps with UCC defaults. That expressly conditional language is your last clear chance to say no deal unless you accept my terms.
So the final thought for you, our listener, is this. If you were drafting, say, your company's standard sales confirmation form, and you absolutely did not want to be bound unless the buyer agreed to your specific warranty terms, what precise, unmistakable words would you use to make your acceptance expressly conditional and avoid accidentally forming a contract on the buyer's terms or by conduct alone? Something to chew on.
That's the million-dollar drafting question right there.
Thanks for diving deep with us today.